just before we start this last session of the day, and in fact, before I say that, we were uncertain how many would have the strength and concentration to stay to the end, and I'm delighted how many people have stayed on to the end, because it's really been fascinating and interesting, but exhausting. I am completely wiped out, and so I imagine you're worse off. Just a couple of announcements. We must finish here at 5:05 and then go to the book signing just outside. And then after the book signing, for those who've still got any strength left and fancy a relaxing drink, then Michael Drake has arranged for us to be hosted at the Athenaeum at the corner. It's just opposite here, just 2 minutes walk from here. And we can have a post-mortem on the meeting and a gossip and a glass of something or two. Yeah, right.
Mike, there will also be a glass of wine available here.
Oh, also a glass of wine. Yes. The other thing about polite scientific discourse, it does always involve a lot of alcohol to lubricate.
Just the one glass.
Oh yeah, I've forgotten about that. Sorry. So much alcohol. The other thing, when we go out to this room, there will be books on the table. Avram's books are there, and he's kindly agreed to sign them. Now, money cannot change hands here, so there's a limited supply of books, obviously first come, first served, and what we agreed is to ask for a donation towards the book online. Norman Williams is going to put an Eventbrite online as a way of sorting this issue out. Money can't change hands, but a donation would be very welcome. Right, so I've now got the delight of inviting Suzanne White to the podium. How long have we known each other? Suzanne White is an expert in medical negligence, medical legal issues, and I think that's how we got to know each other well, not because I was guilty of any medical legal, but I was acting as an expert witness. And as it happens, almost every case was the same. It was all delaying the diagnosis of breast cancer, but that's another story we can address. But,
no, we did our campaigning together.
Oh, and we did campaigning.
Yeah,
we did a lot of campaigning.
Yeah.
Suzanne claims to be an experienced clinical negligence solicitor, but she's actually the head of the Department of Clinical Negligence at Lee Day. Now, in yesterday's Times, you may not notice, they had a league table of the top law firms in the country on the basis of their speciality. And on the basis of Suzanne's speciality, they were top. So she's far too modest. When it comes to human rights, and this is an extension of human rights, Lee Day are where it's at. And Suzanne has an advantage of most other legal experts. She does have some medical background. You were a radiographer.
Yeah, I did mammography actually. So
oh my God.
Yeah, I know.
Well, no one's perfect. Yeah.
Sorry, darling.
No. So Suzanne has faced head-on, one-to-one, the issues that we've been discussing in theory, but in practice. So knowing her for so long, knowing how charming she is and articulate she is, there was no one better, in my mind, to invite to end the session when talking about the legal and ethical issues about the subjects of today.
Oh, what an introduction. Thank you very much indeed, Mike. I'm not sure it's that you can get anybody else to do the graveyard shift that I'm actually landed as the lawyer, talking about some quite difficult and dense judgments about Montgomery and how the law has evolved. And that was my brief when I came here today, was to talked about this great decision on consent for patients and how the law has evolved. And it is very important, and we can talk about the issues we were championing earlier about how we get the message out there about the treatment that women want for breast cancer, how we can campaign for that, and how to a degree the law can help, although it is difficult, as I was trying to outline. But initially, I just want to go through the cases and snippets of the judgments to just take you through the thought processes of the judges and how they come to the decision of why and what a patient needs to know and what they are entitled to know from their doctors. Because there has been a hugely paternalistic attitude by doctors for a very long time. I'll start with the case of Bolan, which has been around for 70 years, which is basically to say, I know best. I'm going to decide what I tell you and what I don't tell you. I'm going to decide the risk I think is appropriate for you, and you'll have to make a decision on that basis. And I think Marcel's example was something that is not new to me. So I'm going to quickly whip through the judgments. I'm then going to just explain a couple of cases of mine to elaborate how it's now working in present day situations, how consent is working in present day situations, and how actively unfortunately, doctors are not just doing it as a matter of course, but because there is the threat of litigation, and this is how it can move medical care on, is when there is the threat of litigation, that doctors actually think, I have to consent a patient properly now, I have to think about their outcomes, I have to decide and clearly tell them what, communicate now, think about communicating about what I have to say to my patient when I'm talking to them about the procedure, whatever it is going to be. Certainly in cancer cases, I think I find that it's different because an oncologist is already on red alert with a frightened patient, the outcomes, the percentages, they've got difficult medicines, statistics to explain to patients. So that, a lot of the cases are to do with obstetric care and risks that not really relate to any negligence by a cancer doctor, because I think they're kind of ahead of the game, I would say. So let's start today with basically the judgments, and we start with Bolan, which was the initial case, which basically said it's a responsible body of doctors that consent you. So anything that a responsible body of doctors would say to you as a consent process was the law. So it had to be the same type of doctor, the same level of doctor, the same expertise as doctor. The expert would look at that doctor and say, well, was that consent appropriate? So that was in the 60s, that decision was made and had not evolved at all until Montgomery came along. And it's a really iconic case because it provided the perfect storm of facts for a challenge. Because that is such a brilliant vehicle for this, I just outlined some of the background of the case to you. So the law needed to move on, and as a result, we looked at Montgomery, went to 3 different stages, went to the Supreme Court, and that was where it was really challenged at the Supreme Court level. And Mrs. Montgomery was a very smart lady. She had a science background. She was pregnant with her first baby in 1999. She was 5 foot tall, so she was small in stature. She was intelligent. She was a graduate of molecular biology. And her pregnancy was agreed to be high risk. And she was also a long-standing insulin diabetic dependent. And as a result of being a diabetic mother, they grow quite excessively big babies. And one of the things they do is they grow quite a lot of layer of a deposit of fat above the fetal shoulders. And so there was that very particular risk about a vaginal delivery and the shoulders getting stuck. And this is called shoulder dystocia, and it's a dire obstetric emergency. So the shoulder dystocia, which happens in about 10% of mothers, is a very scary situation. And what happens to the mother is if there is this shoulder dystocia, they're put in this Roberts position, and this pressure applies to the pubis, and the babies try and get the baby out. So it's an emergency situation. It's danger in doing so. The baby's cord can become occluded, and the shoulder and the mother's pelvis causing the baby asphyxia. So it's serious stuff. So, of course, Mrs. M was anxious because she was a small woman with a big baby. She had a high pregnancy. She measured the size of the baby fortnightly, plotted a graph, and she was frightened and worried. And she'd asked her obstetrician, more than once, would she be able to get this baby out safely because she was a tiny woman. And she specifically directed those questions to her obstetrician, her doctor. Her doctor, Dr. McKellen, chose not to tell her about the 10% risk. And bear in mind, this is quite a long time ago, this case. It's taken a long time to evolve. And She said, that Mrs. M would induce her labour, and she reassured her that if there were any problems, that she would have a caesarean section, and she told her nothing about the extremely concerning risks of her pregnancy and the shoulder dystocia, and did not offer a caesarean section. And when asked about this in evidence, she said, well, you offer these women's caesarean sections, and they take it, and it's not in their maternal interest. So she's already made a decision on how she should treat the patient without any input from the patient herself. Of course, sadly, a problem did arise, and Mrs. M induced labour, and the labour became obstructed. And because the baby was so big and she was very small, it was a real issue. Dr. McClellan, however, astonishingly, did not order a caesarean section. And she told Mrs. M instead that she's going to give her syntocinon, she's going to augment her contractions, and that caused the baby to be forced down even further, so the contractions were even harder. The baby's head came out, but the shoulders became stuck. And then the baby started to asphyxiate, and then an emergency ensued. McRoberts position was, she was put in McRoberts position, that failed. And then by the time the caesarean section was thought of, the baby's head was too low down in the pelvis to do a caesarean. And then they had to do another manoeuvre to try and push the baby's head up. And then they couldn't get the baby's head up properly, so then they had to open the mum's symphysis pubis. You can just see the complete panic in theatre. And then they didn't have the appropriate equipment to open her symphysis pubis, so they had to run off and all the rest of it. Anyway, by the time they actually got this poor little chap out, he had a brachoplex injury, so they'd been pulling his shoulder to try and get him through. And of course, he was catastrophically brain damaged. And astonishingly, the case was aggressively defended. It was considered appropriate not to have informed Mrs. M of the risks. And the case ended up, as I say, going all the way to the Supreme Court. And the claimant's lawyers argued that the principle of the Bolen test was wrong when applied to consent. And the judges expressed their view, stating that the test now for information disclosure should mirror that of the GMC. And I'll talk about the GMC guidelines in a bit. But the test should be patient-centred. The doctor must take reasonable care to ensure that the patient is aware of any material risk involved in any recommended treatment and any reasonable alternative or variant. And the Lord Justices were unanimous in their test. They said, would in the circumstances of the particular case, a reasonable person in the patient's position be likely to attach significance to the risks, or the doctor is or should be aware that the patient would likely attach significant risks to it. And of course, that completely applied to Mrs. Montgomery. They also said the doctor is therefore under a duty to take responsible care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. And the test of materiality is whether, in the circumstances of that particular case, a reasonable person in the patient's position would be likely to attach the significance of the risk, or the doctor is or should reasonably be aware that that particular patient would be likely to attach risk to it. The doctor had to take an intelligent and rational look as to what the reasonable person would want and need to know, and then look about that person himself. Patients have individual special characteristics which may influence to what that patient would be considered material. And in the absence of consent, it is unlawful to do anything to a patient. So the law developed radically, and I can't tell you how it took the medical profession by storm. I was doing a talk last week, and a very eminent shoulder surgeon said to me, I'm scaring all my patients, no one wants to have an operation. And actually, the younger doctors were just like, actually, we think it's a good idea because I think it's the right thing to do, that make sure your patients are consented. It's the right thing that they know what's involved. It's also the right thing for them to say, actually, just tell me, what you think. And they don't want any more information, but it's got to be much more about patient choice, and that's why we're here today, of course. So the law developed, and we have another case, and it is an obstetric case, but it does illustrate how the law is developing. And Sebastian Webster suffered catastrophic brain damage, and it's quite an interesting case. Again, mum was a nurse, a very smart lady, she's 32 weeks pregnant, and admitted with bleeding and a headache. And the doctor wanted to admit her and warned her of the risk of placental abruption. And she was reassured and went home. But later on, scans conducted and the consultant failed to notify her of abnormalities, that the baby was small and there was excess liquor and asymmetry in the head circumference. And it was admitted that he was negligent in failing to tell her about that. So later on, the 26th of December, Sebastian's mother was feeling very well and she went into hospital and she was seen in the morning. The same consultant decided to tell her to go home without letting her know about the previous abnormalities. Now, the claimant's case was that the mother should have been given the choice about being induced there and then, and being fully aware of the anomalies she'd had earlier in the scan, and that she could come back, or she could come back in 41 weeks. The defendant argued that even if she'd had the scan done at that time, it would have been reassuring, not giving rise to the need for a heightened vigilance or advice about dangers. But the claim failed at first instance, and the judge did apply Bolam. And so we were reverting back to the old school judgments. The case went to appeal, and Montgomery was applied again, and it said, I think that the mother had been advised that she should proceed to induction, although there were increased risks in waiting until the 6th of January. She would have wanted to be delivered. I think she was fed up of the pregnancy, the lack of well-being, and it was a due date that she had in mind that she would not have wanted it to be put off, since the prospect of induction was looming in any event. So the mother had, she was very wise to her, her health, and she would have wanted to know about the anomalies, and she made an excellent witness, and the judges really were taken in by her evidence. So by the 27th of December, she should have been told that her pregnancy was subject to unusual features, even if it didn't make any difference to how they managed the pregnancy. But if she had the offer of induction, known about the implication to her baby, as to make a decision about the birth, if she'd been given the information that she should have been given, it is clear that she would have chosen to proceed to an induction on the 27th, and her due date would not have been delayed, and she would have delivered the baby earlier than actually the later date when the catastrophic incident happened, and avoided the terrible damage to her baby. So it's an interesting case in that it overturned our Bolam decision once again and progressed it. There's various cases relating to sort of spinal injury cases, and I'll just give you a quick note of that, because actually in this case it was seen Mrs. Hassel had a decompression operation on her spine, and she effectively wasn't given all the risks of the operation. The risk of the operation was big, and the problems she was having was not great. And so actually she said if she'd been informed and tried all the conservative treatment for it, she would have taken that option. She would not have taken the decision to have this very dangerous spinal surgery. And what was found was actually the doctor, Mr. Justice Dingles, the judge in the case, found that Mr. Bridgeway, this neurosurgeon, had erroneously concluded that Mrs. Hassel had undergone physiotherapy for her neck pain, and because of this mistake did not properly discuss conservative treatment with her. Had he discussed conservative treatment, Mrs. Hassel would have been able to correct his incorrect assumption that there's no criticism of the care given at that stage, and that she would have just gone to conservative treatment and not had this operation. In fact, the operation was conducted completely properly and appropriately, but it's fact the breach of duty for the consent for the operation was not appropriate. So you can see there's a pattern here which has been happening since 2015, that the law is evolving and coming forward and protecting patient choice, which is what it's all about. Very recently, and coming into play just personally, one of my cases, I had a very lovely young woman who had a baby, and she had a very traumatic birth. But she was given, she made it clear in her birth plan she did not want a forceps delivery. She would either proceed to a proper vaginal delivery, but if there was any mention of forceps delivery, she said, can I go to a caesarean section? The consultant wasn't happy about this. And what was unusual is that she ended up having a forceps delivery. They're pulling out the baby 4 times, trying to get the baby out, and eventually she ended up having a caesarean, but she had lots of tears and a badly damaged baby. And what happened in this case is the midwife actually made a witness statement to say, I'm afraid, sorry, I've got a terrible cold. that she was really concerned about the care this lady had had, and she made a personal witness statement which she sent to the client and gave to me, and that was clear evidence that actually the appropriate care had been given because she had not consented to that procedure. So where do we get to? Well, on top of the case law, there is the GMC guidelines, which in 2008 set out very clearly what there is guidance on in terms of consent. And the GMC guidelines said that with Montgomery, this was before Montgomery, that the consent patients and doctors must make decisions together. So regardless of Montgomery, there was all this regulatory information and GMC guidelines which stated how you should consent your patient. So a doctor may recommend a particular option they believe is best for a patient, but they must not put pressure on the patient. Adverse outcomes from proposed treatment should be identified, including side effects, complications, failure of intervention. All of those things should be properly discussed with the patient. The patient must be told of any serious outcomes that might result from treatment, even if the likelihood is small. And very importantly, and I think is quite interesting in terms of best interest cases, is that the patient's decision to refuse treatment must be respected, even if it is wrong or irrational. A doctor must not put pressure on a patient to accept their advice. So guidelines of local trust and GMC can see that actually Boleyn was completely out of date and doctors should have been using the GMC guidelines in any event. So where does this leave us legally and ethically? Well, certainly consenting cancer patients is a very great skill in itself. Patients dealing with uncertainty, grief, fear, loss of self-control. There's concern about death. How does a doctor consent? Well, I think there needs to be a two-way conversation. There's questions, there's answers, there's listening, and I think we talked about this earlier when the psychotherapist was talking about it. And there needs to be careful questions asked. The patient needs to understand their prognosis. They need to ask what their concerns are, that lies ahead, what do they want to do if their health deteriorates. These are all very difficult questions to discuss and require some careful consideration of the person in front of you as the doctor explains that. Of course, innovative treatment is very high in duty, and we talked about the intraoperative radiotherapy today. And consent for that, although I think the whole room would happily consent to it, because in this country it's seen as something innovative, you would have to explain very carefully your options. That's if you get to the stage where you're offered it, of course, because there will be, the fact that there is a new treatment that the statistics are difficult to explain. That has to be really carefully talked through with a client. And one of the cases I did do was where a neurosurgeon had a consent clinic, and I thought that this was a really good idea, and I don't know what you do. But the neurosurgeon basically consented his client for an operation, told him the risk, and then came back and wrote all the information down. The client had come to me and said he wasn't properly consented. You get the medical records and there's a whole clinic of consent. And I think for doctors and for patients, it's a good way to protect you both in terms of setting out what has been discussed and what has been clearly said. So in terms of consent and patients, I've talked a lot about women's health today, but also the psychological impact of patients not being properly informed about their treatment. And if you're talking about breast cancer, treatment is great today, but what are your options? And if you don't know and haven't got informed choice about what can happen to you in the future, or you've felt that you've had a choice in the options ahead, then that is going to have a hugely traumatic effect on you, I think, a psychological effect on you. Women who have babies who don't know that they potentially, can have all these things happen to them because they weren't given the options in the first place, they have really big issues with psychiatric issues. We've got 20,000 women apparently with PTSD as a result of traumatic births. So protecting our mental health is incredibly important in terms of the process of talking to a patient and informed consent so that they can make decisions, and that will help them with the process of the decisions they've made and the treatment they're going to go through, regardless of what that is. So in terms of today, we've got very dynamic doctors here with brilliant treatments, and I think the process of how we consent patients in the future in Montgomery is something that's really going to help our doctors in the future with dynamic and brilliant, innovative treatments in the future. In terms of how we can proceed with what we talked about earlier, I think we can talk about it now as a sort of interaction between the audience and ourselves. But there's, I think patient power is the way forward. In terms of campaigning, the law is difficult. We've talked about Human Rights Act, which is a potential, obviously, but that's crowdfunding, challenging, takes time. We can talk about how we can judicially review public bodies about their decision not to give patients treatment. But if we've got a room full of women who are saying, you are not giving us options, we are not getting the best care, not only are we not getting the best care, you are not saving the NHS money, then that is a really powerful message. And so I sort of endorse everything that's been said earlier. But very happy to take questions, and I'm sorry my voice is completely dying on me.
Bravely with your voice
I got
drifting
kicked
away.
out into the spare bedroom last night because I was coughing so much.
We are desperately short of time, and I promised Dr. Renner she'd asked me that she wanted to address something, and which is an issue of, I think, medical legal consequence of a generic issue, and I thought it was a good point. Then we need to revisit the issue of GPs having responsibility but without representation. Do you want to make that point? The issue of GPs having responsibilities but without representation. We're dealing with three separate issues: screening, HRT, and intraoperative radiotherapy. I think you wanted to say something.
I mean, for me, the major issue at the moment with GPs is not really being at all up to speed on HRT.
Yeah.
The current stats and how dangerous it is not. And I find that quite tragic. Women on a day-to-day basis who are being treated accordingly or not being treated at all, and being sent away in misery. And so really it was just that if I'd have done the menopause talk, for me it was about how we address GP education.
Right. Now, the reason I wanted you to say that, not me, was, is this a Montgomery issue? Do you think, having heard what you've heard today, that it's the GP's responsibility to talk about the options of radiotherapy?
I think it's the responsibility of the GP to say that these are your options. And I think what is quite compelling, I think we were talking about this earlier, is that actually if it's a nice guideline, then they could be on a sticky wicket for that. Whether we can go as far as to say, well, actually, these are your options, but this is the gold standard of care, but at the end of the day, it's an issue on funding, and whether you're obliged to be able to get that care is, I think it's a difficult, it's a sticky wicket, because there are lots of public funding arguments about health, about cancer, about.
But I think when we have patients coming to us or coming to doctors about their menopausal symptoms, and they're being told that it's depression and being given an antidepressant which does absolutely nothing, or they're being told menopause is a natural thing, go away, or you're still having periods so you can't have HRT, go away. And these women are then losing their jobs, losing their relationships, and their life is falling apart. At some point in the future, they could almost come back to that doctor and say, well, your advice was so shoddy, and my life fell apart, and these were the ramifications.
Yes, but that advice is more of the Montgomery is about the consent, whereas the actual care is about the Bolam test. What I don't really want is that, we're having to force doctors to give decent advice because they're going to be sued, rather than actually they need to do it I mean, that's what I was saying. Montgomery has driven consent off the wall. You know, people are up, you know, doctors, midwives, everybody is like, I need to consent properly, I need to tell the patient this, I mean, what, you know, all of those things. And it's really sad that it's been driven by litigation instead of actually good practice by GPs.
And
so
GP should
it's
be
another way of doing that. But yes, there is the threat of, you know, not appropriate care, not giving the patient the options. And actually the bigger picture, which is a political issue, not really for lawyers, is the politicians need to take on board that what doctors are saying to them is that if you improve, you know, if you give HRT, you improve women's lives, they are going to go back to work, they're not going to be depressed, they're going to sort of contribute to, you know, to the economy, all these arguments that we're all on the same page with.
Yeah, and from a GP's perspective, we're talking about 50% of their cohort
Yeah.
at some point in their lives.
Sorry, there's only time for one more question. I'm very sorry, but we overran, and we've got to be out the building at 5:30.
I'll be very quick. And essentially, you've heard, Suzanne, that with respect to intraoperative radiotherapy, it was developed in the UK. It was published in a very prestigious, The Lancet Medical Journal. And it's been embraced in Germany, as we've heard. It's been embraced in Israel. It's been embraced in Australia. It's offered in Italy and in other places. Now, the key question for me is this. Is it, from a consent point of view, is it a breach of duty to offer it in the UK on the basis that it's been obstructed for whatever reason and therefore it's not standard of care? Or is it a breach of duty not to offer it? Because it has to be one of those. It's either a breach of duty one way or it's breach of duty the other way.
Well, it's the whole picture of consent, isn't it? So it's what are your options? Now, is it a breach of duty? I mean, you can tell me as an oncologist, you know, would a responsible body of oncologists not offer that to the patient? Do you think
in the UK, I think they would not.
It's an expert's question, not a lawyer's question. I can't tell, you know, I'm not an oncologist. I can't say, yeah, would a responsible, but is there one oncologist out there would actually not offer it? I suspect there might be, and that's the problem we've got.
Yes, there are a lot of oncologists who would not offer it.
It's not a consent issue, because once you've decided to say, look, these are your options, then Montgomery comes in and says, okay, this is how you consent your patient. But is it a breach of your duty, a Bolam test, not to actually offer that in the first place? And that's an expert.
The issue is this, that if it is even mentioned, merely mentioned, you know, there is intraoperative radiotherapy, but I believe it's of no use to you. The patient is then in a position to find out more should she wish. The problem we're facing is that it's not even mentioned. Quite often patients, as you've heard today, have found out by serendipity how that intraoperative radiotherapy even exists, let alone consider it as an option.
But that's, I mean, it's disgraceful. But is it a litigation point, or is it an education point for oncologists to be offering their, you know, all the answers are to sue? And I think that's the wrong dynamic we were talking about. But maybe it's the only threat. But ultimately, as a next, you know, I would, as a lawyer, say to my expert, do you think all oncologists should be offering that to their patients?
Yes, I do.
Well, then there is.
What I do with my patients is I tell them there is this option. I cannot offer you on the NHS because it's not funded. But I feel that I'm in line because I do that.
Maybe the answer is you have to give them all the options, and then they make the decisions from themselves to make, you know, to have that choice.
I'm very sorry, I have to stop the discussion. I've got a few concluding remarks, and then Gerard Dugdale is going to have a vote of thanks. So thank you very much. I just really want to say two things. There's a lot of passion and buzz in the audience. It's been like that all day. There's so many questions you're desperate to ask. We're not going to let this slip. And Jayavadi has suggested setting up a Google group, which is a very safe way of continuing this dialogue. We want the dialogue to continue. This is merely the start. We've got a long way to go, and the chemistry of this meeting has been quite extraordinary. I've never seen anything like that before, and I'm deeply grateful. The other thing I need to say, talking about empowering women, and I want to tell you a very brief anecdote. so that you understand a little bit more the scientific process. We're talking science. You've got to understand science. In August, I was invited to give a plenary lecture at an international meeting in Copenhagen, sponsored by the WHO, on how are we going to de-implement screening. Now that may surprise you. International bodies are now talking about de-implementation. So the way I started my talk was to give them a quiz. A bat and a ball costs £1 10p. £1 10p. The bat costs £1 more than the ball. How much does the ball cost? Everyone says 10p, but that is wrong. The ball costs 5p because the bat is £1 more. It's £1.5 versus 5p. Now the relevance of that stupid example comes from the book Thinking Fast and Thinking Slow. All of us are guilty of thinking fast. It's effortless, it's spontaneous, it happens all the time. Scientists have to think slow. So we think slow and we try to think about those facts that don't fit. If you want to join this wonderful game, you've got to learn to think like us. You've got to attend meetings from 9 to 5. No more whinging about transport and breakfast. You've got to do your bit to allow us to do our bit. But so far, everyone in this audience has done their bit and it's been electrifying. Thank you. I now want to call upon Mr. Dugdale for a vote of thanks.
Thank you very much, Professor. I'm going to talk for about 52 seconds. I just want to say simply thank you to everyone and every organisation that has helped put today's event together. And whoever you are, whatever you are, you need to give yourselves a pat on the back with appropriate heartiness. And I think in all cases that will be a very generous pat on the back indeed. I think, as Mike's been suggesting throughout, we've brought together a great mixture of people today to develop the conversation into these so important issues of patient people care. And as we've also indicated with the Google group, or you can contact any of the organising organisations. Let's move on. Let's keep the conversation going, and let's see if we can help people into the longer term. So we've got the glass of wine and the book signing just outside, and then we've got the longer reception from about 5:30 at the Athenaeum, which is around the corner, and you're welcome to linger there. So I think everybody needs to say thank you to everybody. Thank you.